If you're in the retail industry as a supplier of goods or services, as a retail store direct to consumers, as a wholesaler or distributor, or any type of retail business, you will likely have a number of business relationships that involve some type of contractual commitment or obligation. So understanding the basics around contract management and the legalities that are involved will be important for you. Contracts effectively outline expectation for both parties and help protect both parties if those expectations are not met. There are usually consequences to failure to meet these obligations, and if these failures are on your side, they will impact your business and in some cases can impact your life. And if these failures to meet obligations are not on your side, they can still significantly impact your business, and it's necessary to have protections in place. Having the law behind you in a contract will help protect your business. Today we're going to discuss some of the basics around understanding contracts, and especially those that impact the supply chain. We'll be discussing the components that are required to form a legal contract, and all of these elements need to be met for a contract to be legally binding. We'll then cover some of the benefits that having a contract in place can bring to your business. We'll discuss how verbal contracts are legally binding and how you can substantiate them. We'll cover what a standard contract template looks like, and we'll go through the 8 sections that need to be included. We'll then cover the types of contracts that you commonly see in the retail industry that you're likely to be dealing with. And lastly, we'll go through the general legal requirements, and this will cover the implied terms and basic legal requirements that are present regardless of whether they're mentioned in a contract or not. So we're going to start with what is a contract and what is needed to ensure that a contract is valid. A contract is a legally binding promise made between at least 2 parties in order to fulfill an obligation in exchange for something of value. They can either be written, oral, or a combination of both. For something to be considered a contract, there are 4 key elements that need to be included. The first is agreement. This covers the offer that's been made and acceptance of the offer between the 2 parties. The second is consideration. This is what one party will be paying the other party. The third is intention, that you mean the contract to be legally binding. And fourth is capacity. And this covers your ability to understand what you're agreeing to and the obligations that you'll need to fulfill within the contract that's been undertaken. So what do these mean? Firstly, your offer. An agreement will happen when an offer is made by one party and the offer is accepted. The offer is basically the person making the offer setting out the terms for which they are willing to be contractually bound to. And the second part of finding agreement is acceptance. An acceptance of the offer must be unconditional. For example, a signature on a contract. This makes it 100% clear that the offer has been accepted by the other party. The second element that's needed to ensure a contract is valid is called consideration. And consideration is what one party will pay to complete the contract. And payment is a loose term when defining consideration for a contract, because what one party gets for signing the contract isn't always money. But ultimately, consideration is considered something of value, and usually it is defined by a monetary amount. The third component is intention, and not all agreements between parties are contracts. It must be clear that the parties intended to enter into a legally binding contract. In the case of business agreements, the general assumption is that parties intend to enter a business contract. If you consider social situations, there is generally no intention to enter agreements and for them to become legally binding. For example, if you plan to meet your friends at a certain time for dinner, it's not a legally binding contract. And alongside showing your intention for the contract to be legally binding, another aspect to consider is that the contract terms must be lawful. You cannot enter into a contract to complete anything that is not lawful. And lastly, you need to have capacity. All parties who enter into a contract must have the ability to understand the terms of the contract and any obligations that they are undertaking within the contract. For any contract to be legally binding, consent must be given freely. You cannot have any level of coercion, undue influence, or fraud involved. To be considered legally binding, all contracts must adhere to these components. There are many benefits and reasons to have a contract in place for your business, and I'm going to cover what I feel are the most important. Firstly, having a contract will help you navigate the law. For most people, they find the law complex and confusing, and having a contract in place will help make the law more accessible to you and to navigate it correctly for your business. There are many templates that are available online, or you can find some support in professional advocates to create these contracts for you. The second is having a contract in place will help you get paid. I'm sure in your list of business priorities, getting paid is at the top. A contract will help you communicate clearly to everybody involved what's expected in terms of payment and when it's expected. And if somebody is unable to meet their obligations or just chooses not to meet their obligations, having a contract in place will mean it's legally enforceable to help your business recover the debt. Thirdly, a contract will help you minimize the amount of issues and disputes that you do incur as a business. Part of the detail in contracts will consider what happens in case of disputes, and you will agree resolutions in advance. And again, they're enforceable by law. But it also allows both parties to consider what they're taking up in terms of their obligations as you put the contract together. And it means that generally there's good intention to try and meet those obligations. By having clarity at the start, it can help minimize the amount of disputes or problems that do occur. And in the event that they do occur, you have the law on your side to help resolve them. A strange one. Having a contract in place can help you give good customer service to the people that you're serving. By having a contract in place, things such as returns, refunds, repair policies, any intellectual property, any complaints procedures, these elements will be part of the contract, and thus the customers will be aware of them in advance and will have a clear route to follow in the event of any of these. By setting out your terms and conditions, you are effectively communicating clearly to your customer and managing some expectations. And alongside managing expectations, when you put a legal framework in place, you're helping to build trust and give all parties peace of mind. This contract will show you how your transactions are protected, and it will provide peace of mind to everyone involved. Now we're going to touch upon verbal contracts. And as a general rule, the law in the UK and in Northern Ireland does consider verbal contracts to be as legally binding as written ones, and they do hold up in court. So they do help protect your business. However, of course, the obvious difficulty in verbal contracts is proving the detail within the contract, and this holding up in court. Gathering evidence to prove the terms of the contract is more time consuming and complex than if you have a written agreement in place. The same four elements are needed to prove a verbal contract: agreement, which includes offer and acceptance, capacity, intention to enter into a contract, and consideration. In a retail business, there are many times that you'll use a verbal contract. And if your business is working well and the contract obligations are being met by both parties, there is generally no issue. An issue only occurs, of course, when one party doesn't meet its obligations and when there's no agreement and the court needs to intervene. Proving a verbal contract is the difficult element. And if you find yourself in this situation, these are some of the things you can do to gather evidence of a verbal contract. The first is to source witnesses, and this is one of the best ways to demonstrate some of the terms of the verbal agreement. Individuals who witness the conversations between you and the other party, or if other employees were dealing with any part of the deal, from taking the order to delivering the goods, etc. These people can both validate the elements that are needed from a legal point of view to confirm that an agreement was in actual place, but also can confirm some of the specific details. The second area to look at is documentation. It is perfectly possible for you to have written documentation that demonstrates the terms of a contract, even if you don't have a written contract in place. If you have emails, text messages, bank statements showing payments were made, invoices that were signed, all of these things contribute to highlighting that a verbal agreement was in place. And the third element is what's called considering actions. So, for example, if you run a social media company and you're providing a service to somebody and they stop paying their bills, even if you had no contract in place, if they've paid the bills for 4 months and then stop paying, this is what's called a considering action. It highlights that there must have been an agreement in place and an understanding. The same process would apply if you were supplying somebody with carrier bags for their retail business, hair colour for their salon, or any inventory for their retail business. There are ways to gather evidence for verbal contracts. And it's important to note that verbal contracts are legally binding in Northern Ireland and in the UK, and that these can actively help protect your business. I'm now going to take you through what would be considered a standard template for a contract. When you're setting terms of a contractual agreement, it will depend on whether you are selling products or services or are the buyer. And of course, at times you may be both. And there are many templates and sample agreements that you can download and take from online. But any agreement should be thorough and specific to your specific business circumstances, so sometimes default wording is unlikely to be sufficient. Depending on the size and scope of your business, it's worth considering at this stage to get some legal advice when you're drawing up your terms and conditions. You can take advice and help protect your business vulnerabilities. It can even be a once-off support to have the template set up. But regardless of whether you do it yourself or have some legal support, all contracts will include the following sections. The first will be the commencement section, and this is the day on which the activities in the contract will commence, not the date it's actually signed. Another term you'll commonly see used in contracts is the effective date, which is the same thing. So effectively, when the contract will start, and importantly, when the contract will end. The second section will be the party details, and all parties involved in a contract must be properly identified. And by this, I mean legally identifiable. It should include full names, addresses, company registration numbers where they're relevant, and of course, the country where they are incorporated. Where it's possible, try and get proof of address and proof of identity. The third section is the definition section, and this is fairly self-explanatory. It's a section with an explanation of any specific terminology used in the contract to ensure easier understanding and referencing throughout the contract. Sometimes the legal language can be confusing to us laymen, and the definition section will help with any explanations. The next section that you'll see always included is conditions precedent. And a condition precedent is an event which must take place before a party to a contract must perform their duties. So for example, if you've agreed to paint a garden fence and the contract states that the owner of the fence must supply the paint, until this paint is supplied, you are not required or able to paint the fence. This is a simple example but illustrates the point. If a condition precedent does not occur, there is no duty of performance that arises and no payment is required. And importantly, the party protected by the condition is not in breach when the party does not perform his or her part of the contract. Commonly used condition precedents in retail contracts could be receipt of the legally signed documents. Nobody wants to send goods to somebody where they don't have a legally binding contract in place, or it could be dependent on receipt of some deposits or monetary security such as bank guarantees, etc. The next section that will be included in the contract is called the responsibility section. And this is effectively the substance of the contract. And it will include all matters related to the performance obligations, which party will be required to do what, specific details of what actually needs to be done, where the work needs to be completed, how the work needs to be done, and of course when. This section will also set out the payment terms, which party is to pay whom, when they are expected to pay, how the payment details are to be made, for example, bank transfer, cash payments, deposits, etc. If there's any minimum payment terms, if there's to be any price increase formulas used, what happens if payments are late, who's responsible for VAT and any other tax issues. A lot of the substance of the agreement is included in this section. The rest of the sections in the contract are effectively clarifying details and protecting the business vulnerabilities of the parties, but the actual substance of the contract, who is doing what and when they're doing it, and for whom and for how much, is included in the responsibility sections. And this leads us on to the next section, which is the limitations and exclusions section. And this section is to detail how risk will be apportioned between the parties and how the limitations of liability will be from one party to another. It's generally used to limit liability to the elements of the actual contract and can either cap liability or exclude it altogether. It effectively states that the entirety of the agreement between the parties is set out within the contract and sets to limit the liabilities of the parties to a contract to only what is covered in that contract. If you're running a retail business and you're buying or selling goods to another party, This limits your relationship to buying and selling goods with that party and ensures they can't impact or influence any other part of your business. The next section is what's known as standard clauses, or is referred to as boilerplate clauses. And basically these are clauses that are standard to any contract that you'll sign. And while I say they're standard, they're also legally binding, so you need to ensure that you check the detail if you're using another party's standard boilerplate template. But by creating your own set of standard clauses, you can increase efficiency and reduce the amount of time and money spent on drafting documents. You can ensure consistency across all the agreements that you sign, and you can take advantage of your prior experience. You'll learn something from every transaction. And importantly, you can ensure that they meet the specific needs of your business. If you're developing your own standard set of clauses, consider the needs to your own business and decide the detail, and be sure to include things such as force majeure, the law and jurisdiction of where the agreement will be valid. For Northern Ireland, it's common to see agreements for Northern Ireland, the Republic of Ireland, Europe, etc. Consider the confidentiality provisions and what's necessary to protect your own business. Decide how you'd like to see disputes resolved, and consider the options of arbitration and mediation. Decide whether you want to give any third-party rights or to limit them or exclude them. Consider the termination rights. Again, for help with this, there's a lot of detailed information available online where you can take a standard template. My main point is that you need to ensure that it meets the needs of your own business, so ensure you edit the detail. And this leads us on to the last point, which is the schedules and appendices section. And this is a section that's used to attach information, usually at the end of the contract, where it will be too confusing or cumbersome to include in the main body of the contract. Schedules often take the form of lists or descriptions of information. So an example in retail could be, if you distribute a brand, it could list out the stores specifically where they have the right to sell your actual brand. You may not want to give a business rights for their whole business. You may want to pick their top 10 outlets specific to large stores on high streets. It can include things such as payment schedules. It's often used with retail leases. It will state check dates and the value per quarter over the lease period. Schedules can include anything that is a large amount of detail that's needed for the contract and required for each party to understand, but that is too cumbersome to include in the main body. Regardless of whether you're a buyer or a seller or the type of business you're in, these 8 sections will always be included as part of a standard template for any business contract. We're now going to talk about some of the most commonly used contracts in retail, and the first is the franchise agreement. And a franchise agreement is where a brand gives you access to their brand and their operating system. The franchisor or brand will remain in control of the brand, the name, and all of the business system. But the franchise agreement gives you rights to operate that in line with its system. And the agreement sets out all of the obligations and rights that you have in terms of the relationship. And it's there to protect both parties. It will usually cover all areas, including pricing, territories, expansion, trademark and intellectual property rights, provide marketing materials and advertisement. Effectively, it should cover everything you need to allow you to operate the brand to the required standard successfully. Another common document used in retail is lease agreements, and these are effectively long-term rental agreements. You are borrowing something over a period of time for an agreed cost, and then you return it when the contract ends. Both the leasee, which is the borrower, and the lessor, who is providing the space, both face consequences if they fail to uphold the agreed terms. The most common use of leases in retail are for retail properties for selling goods, for office space, or for vehicles. Another commonly used legal document in retail are NDAs, which are non-disclosure agreements. These are confidentiality agreements which are legally binding and enforce secrecy over confidential information between businesses. NDAs can be either one way or by mutual agreement for both parties. There are many reasons why retailers would use non-disclosure agreements. You may find that your supplier is also supplying your competitor and you don't want your information to be shared with anyone. There are many reasons why you would want an NDA in place. Another commonly used document that is a legal contract is a purchase order. And a purchase order is a document that you send to a supplier requesting to buy their goods or services. It confirms what is being bought or sold, the contact details of both the buyer and the seller, as well as the price and payment details. If the supplier accepts the request, it is considered legally binding. Another type of contract you will see often are service agreements, and service agreements are written contracts that set out the terms between a customer and a service provider, and most service agreements will cover things such as payment terms and timelines of work. It is similar to the bill of service or a purchase order, but it defines a service rather than actual goods. It would be frequently used in retail for contracts related to social media support, building websites, internet providers, etc. And if your company provides professional services as opposed to selling a product, you will need to have your own services contract in place. The agreement will lay out your terms and conditions which you provide your services and will spell out your responsibilities and liabilities. And having a good contract here is important because you want to try and avoid any misunderstandings and undue liability. Another common type of contract you'll see often in retail is the website terms of use agreement. In today's retail environment, most businesses have established a website to market their company and their products. And essential to those websites is a terms of use agreement. This is intended to be a contract between the website owner and the users of the site, and that any purchases of goods or services on the site will be covered by this agreement. A good terms of use agreement is essential for avoiding legal liability to the site owner. It will cover many things, including limitations on how the site can be used, copyright protections, liability limitations, and disclosures on the website's privacy policy. There are many other types of contracts that you'll find in retail, but these are just some of the key documents that are used regularly. And as always, the main goal is to be clear about the obligations of both parties to help you navigate the law and ensure that you get paid at the end. A well-written contract will minimise disputes and clearly manage expectations and ultimately protect your business. There is much law in place to protect the sale of goods, and regardless of whether you include them in your contract or not, they will be implied terms and will be recognised as legal requirements. And you may ask, what are implied terms? And these are terms that a court will assume are intended to be included as part of a contract, even if they're not expressly stated. And I'll give you a simple example. If an individual enters a restaurant and orders some food, a contract is said to be in place to receive the food and service, and the payment is confirmation of the same. If that individual didn't receive the food or service as expected, they would be entitled contractually to a refund, as the contract is deemed legally binding. I'm going to run through some of the most popular implied terms that would apply to your business and the sale of any goods. Firstly, you must be entitled to sell the goods. Secondly, the goods must match their description in appearance and in durability. Goods must be fit for purpose, and you cannot sell goods that are defective or unsafe. The implied terms also apply to service industries. For service, there is an expectation that the service will be carried out with reasonable care and skill, that the service will be completed within a reasonable time frame, if no time frame has been set in advance, and that the service must be provided for a reasonable price. And again, this is no price has been agreed in advance. Some of the other general legal requirements that are in force regardless of what's in a contract are that customers are entitled to a 14-day cooling off period. So if you're not a B2B and you're selling to customers as end users, customers are entitled to change their mind and entitled to a full refund during that 14-day period. Also, if you're a business that's selling to end users, all customers will have statutory rights and you must adhere to those statutory rights. And lastly, you must comply with any specific regulations which apply to your industry. So, for example, if you're selling groceries and alcohol and tobacco, you must comply with the laws regarding the sale of alcohol and tobacco.